Yes, Sujata ma'am, you can start.
Yes, sir. Thank
Yeah.
you, sir. Good
Ma'am,
afternoon
you
to
need to
all.
be a little bit audible.
Yes, sir.
Yeah.
Good afternoon to all, and welcome to the webinar on intellectual property rights and filing of patents. I would like to introduce our resource person, Dr. R. Bhanumati, Assistant Controller of Patents and Designs, Patent Office, Chennai. She has done her postdoctoral research on intellectual property in biotechnology, University of Bologna, Italy. She has done her PhD in biotechnology from Rajiv Gandhi Center for Biotechnology, Trivandrum. She has represented India at 31st WIPO Standing Committee of Patents at Geneva, Switzerland in the year 2019. She has a lot more to her credit, and I would like to thank her for accepting our invitation without any hesitation. Now I hand over the session to her. Ma'am, thank you, ma'am. You can take over.
Thank you very
Thank
much.
you, ma'am.
Ma'am, before you start, on behalf of the principal, management and IQAC and also the library, I extend a very warm welcome to Dr. Bhanumati, a wonderful person and a person with a lot of knowledge in intellectual property rights, and she is the right person to enlighten us today on the topic intellectual property rights. And now, may I now invite our principal, Dr. Santosh Babu, to say a few words before we start. Sir, can you join us?
Yes, are you able to hear my
Yes,
voice?
yes, sir. Yes, sir. We are able to hear.
Very nice, very nice. Good afternoon, one and all present here today for this lecture. Actually, the Dr. Bhanumati have taken a very good topic, and also as part of Intellectual Property Rights Association, he is going to talk to us in various aspects of intellectual property rights, and especially with respect to that, as a faculty member, we used to do research and also write papers for the conference and journals. In that, we will be having a very important problem, is a copyright problem. So the copyright problem is very important, and when you are not following the copyright correctly, there comes the plagiarism. So the plagiarism can be defined in two ways: is after putting a reference, you can use it. In some cases, if they have a copyright of a particular product, even after putting a reference, you could not use it, and you have to get a letter from them. So this is the main problem with us with respect to copyright and other things. And apart from that, in a trade and other business organization, this copyright is very important, and the patent also is very important. So when you find out any new device, or new methodology, that has to be patented properly. If you patent it properly, you will be getting if anybody is using it, or if they could not claim the rights on the particular property. So this is a very important topic. I like to congratulate the organizer for selecting the right topic for the faculty members and the participants. Thank you very much for giving this opportunity. Thank you.
Thank you very much, sir. Now we hand over the session to Dr. Bhanumati. Ma'am, please, ma'am.
Good afternoon to all of you. Today we'll be talking about intellectual property rights, the basics, and how you need to go about filing, and what is the procedure in India. Am I audible?
Yes, ma'am, you're audible.
All right.
Yeah.
So, intellectual property rights starts actually with an idea. You get an idea, and you would want that you have to actually work out on it. So, all patents or say any innovation started with an idea. So, it can be something very simple, and it could also be very complex. So, if you see the past patents or the past innovations, if you could see the past innovations, they have been in diverse fields of technology, and it has started in a very simple manner, but as you see, it has become more and more complex. So I have some examples here where the vehicles, or you say cycles, how it has started off. You see, each one of them is a simple invention which has arisen due to the necessity. Okay, it could be simple or it could be complex. The applications could be varied, but it comes with a purpose. So if you see here, you have different kinds of innovations with applications. So if you see the design of a car, for example, you have something like in 1935, the design was more simple, and as you go ahead, you see how much of a difference it has made. Okay, and intellectual property rights is very important because only when there is involvement of labor, innovation comes when it is reaching the public. So if you are making new and new innovations, it comes into the market, people use it, and you can make money, and again investors go into and try to improve. So improvement comes into the market only if there is revenue. So IP is very, very important. Otherwise, we would be still in this 1935 car model. We would never have reached the 2020s. So let's see what is intellectual property. Intellectual property is a creation of intellect. It could be in the industrial, in the scientific, it could be in literature, or it could be in artistic field. It is not restricted to just one field. It could be in any of them. The intellectual property rights, once you talk about the rights, it is an exclusive right which is given by the government. To whom? To the owner of the property, the person who made the property. And what is the right? It is for commercial exploitation, subjected to the national laws. The countries have their own laws and international agreements. Based upon the international agreements, there is, you can actually exploit your invention. And why do you need to exploit it? Because it is a reward to the innovation you made it. This intellectual property rights, they can be either assigned or you could license it for financial benefits. So the point is, if you make an innovation, you can sell it and you can make money, you will get the benefit, and the people will get the reward, and the people will get the advantage of the new products in the market. Intellectual property is actually a collection of tools. There are many different kinds, it's not just one. So you have two major classes. One is the registered rights and one is the unregistered rights. Registered means you have to register it. Okay, without registration, it has no value. So for example, like you have the patents, the trademarks, the designs, and the geographical indications. We'll be seeing what each one of them are in a little later time. So if you don't register it, you don't get the right. And there is something called unregistered rights. That is, the moment you create it, it starts. Okay, so they are called the unregistered rights. You could register them or you need not register them, but the moment you create it, it has arisen. Okay, so for example, like copyright or confidential information or passing off or unregistered design right. The moment you make it, the right has started. If you register it, you get extra privilege. If you don't, you can just leave it like that. Like say for example, Leonardo da Vinci's paintings. The moment he created the drawing of Mona Lisa, it is, the copyright has started, but he has not registered it. The same thing with the confidential information. Like say for example, the Coca-Cola formula. The concentration or the components in this formula is confidential information. It is not registered anywhere. Nobody knows what the formula is. But it is a confidential information and it is again unregistered. So, if you see intellectual property, I told you there are various types. So, these are the various types. So, we'll see one at a time. The first is patents. Then you have trademarks or service marks, geographical indications, copyright, designs, trade secrets, layout design of integrated circuits, and plant variety. So we'll see what is patents. Patents, designs, and trademarks are part and parcel of one product. So anything dealing with the constructional features of an invention comes under patents. Say for example, the cooker. If the mechanism of this cooker is different from others, say for example the nozzle design or the valve design, okay, the functional feature of that particular new innovation, that you get patent protection. The design, if you say a new shape, okay, or a more appealing design of this cooker, you will get the design protection. So a modified shape, pattern, or a configuration. It could be the handle, it could be the nozzle, it could be the whistle, it could be the shape of this. Okay. The third part is the trademark. The word, the name, or the logo which you can register. Say for example, cooker. The moment you say cooker, you know Prestige or Hawkins or so many other brands. So the name which helps you identify, like butterfly. Okay, that name which identifies, that is called a trademark. In industrial property, these are the three most important ones which are in existence. So we will concentrate more on these three. So the first thing is patents. Now what is a patent? Patent is for the constructional feature of a invention. Say for example, if it's a drug. In the drug, what is the composition of the drug for a particular disease? Now that nobody knows. So that for that particular thing, you will get a patent. Say for example, this table, which is there in this picture. It has a very innovative kind of a table. It could be open, it could be, you could make it big, you could make it small. You have different construction features which could be utilized for different purposes. Now, all these features can be used for patents. When you file a patent or when you get a patent, it's a contract between the inventor, the person who invented it, and the state. State means the country. Okay, and the rights which you get from this is territorial in nature. So if you file in India, you get the rights only in India. You can't exploit it in US. Or if you get a patent in US, you can only use it in US. You can't exploit it in India. And this is for a limited period of time. It's not forever. The time period is 20 years, not beyond that. After the 20 years, anybody can utilize it. This is for inventions. It can be a product, say for example, a medicine, a drug. It can be the process, like the method of making that, or it can be the apparatus. Say for example, this. The requirements is it has to be new or it has to be novel. It should not be something which is already known before. Okay, and in response to getting a patent, you need to give full disclosure. That is, after 20 years, somebody should be able to make it. The terms, if you need to get a patent, are state specific. Like there are some things in India which you can't get, which you may get in US. Like say for example, method of treatment. That's not allowed in India, but it's allowed in US. The protection. The protection for the patent is defined by the claims. The claims are the most important part of your patent application, which you will draft. Patents are expensive to get and are a little time consuming. They are difficult to obtain if your invention is not properly drafted or is not novel or inventive. And it is expensive a little to enforce. If your invention is really good, then there will be a lot of people who will try to exploit it. Say, for example, the COVID vaccine. If, say, for example, somebody is really able to make the perfect vaccine with no side effects, then imagine everybody wants it. Whatever the cost, people are ready to buy it. So once a vaccine comes, there will be n number of companies who will be trying to find out what is there in that which is working, which is not available elsewhere. So can we really re-engineer it? So there will be so many people who will be trying to do similar products. So once you get a patent also, you have to see that nobody else copies it. Or if somebody copies, you should see how you can stop them or sue them. Okay. Coming to the second part, the designs. Designs is for the design of an article. Say for example, this picture here, the TV. You have so many different kinds of TVs, TV monitor, which are available. Or say for example, your mobile phone. There are so many models coming every other day. So in a month, I think you have some 10 to 15 models of different phones coming out. So each one is having almost 90% of the features are same, but still there is a little difference. Now that is what is the design. And each new design comes, it is the basic thing is it has to be appealing. So when you have a mobile in your hand, it is because of its appeal to you. The look is much more significant. So for registering a design, the first thing is appealing to the eye. Second thing, it has to be new. And even if it is out in the market, you still have 1 year time within which you can register. And once you register, you get a registered design number. So once you have this number, whenever you buy a product, you can see there will be a mention of the registered design number. You can also use designs to protect computer graphical items. But the problem of designs is even if there is a slight change, somebody else can get the design. Say for example, in this picture, you have seen two different items. If there is a little different design on it, or you say serrated lines on the oven, the design will be different. If the handle is a bit changed, then again you will get a design protection for that. So you need to do very little alterations and you can get a new design. So you will have to think in all means possible when you register your design that nobody else can copy. Industrial and handicraft items, they can be registered. But the most important feature is it must be new and it must have an individual character. The timeline for a design is 5 years and you can renew it till 25 years, not beyond 25 years. Industrial designs, they come in different classes. So based upon the category of item you are actually designing, it will go into different classes and it is searched in that particular categories. The next most important thing is trademarks. Trademarks are any words, names, logo, symbol or device which a merchant can use to identify himself or his product. So for example, when you see Google, you know it's a search engine. Or Infosys, you immediately know that it's a software giant. So any sign which can be used for trademark has to be distinctive. Okay, and you can acquire trademarks either by use. You don't need to register. You can start using, and once it gets the name, the brand name, you can register it, or you can first register it and then you can apply and you can start using it in the market. The protection is variable and it depends upon how distinct the mark is. Okay, the cost is not expensive like patents, it's quite reasonable, and the amount of protection is lengthy. As long as you renew it, you will keep on getting extended lifespan. But the moment you don't renew it and somebody tries to apply it or use yours, you cannot go to court. So it is very important in all intellectual property that you pay the renewal fees so that your intellectual property, whichever you have registered, is alive. And so during that period, if somebody uses your invention or use similarly without your permission, you can actually go to court. But if you have not paid, that means it is invalid, and that time if somebody uses, you cannot actually go to court because since you have not paid it, it is dead. Okay, so you have to continuously keep renewing it for the lifetime of that particular invention. Say for example, patent, it's only 20 years. Beyond it, even if you pay, there is no protection. For design, maximum is 25. But for trademarks, it goes on. And trademarks is a very, very important part of IP, because you can see that the name value is so big. Like say for example Google, you say for example Tata. These are all big, like prestige. Okay, these are distinct, very distinct and very powerful names. So you actually associate a product based on the name. So if you say it's a prestige property, or you say prestige cooker, or prestige oven, you know that that brand has a value. Okay, that the product will be good. You have that belief, that goodwill which comes, it comes from that trademark. That is why trademarks is very, very important. So the next thing is trademarks. You can apply for the mark before use, and for a single class of goods, or you can apply it for many classes of goods. Like say for example Godrej. Godrej was first associated with fridge, but later on they have actually gone ahead with washing machine, and now you have Godrej properties, and now you have Godrej in retail, like say for example food products and all that. Same thing with Tata. Tata is there with watches. You have properties, you have vehicles, you have this. One trademark is applied for multiple category of goods. Or you have trademarks associated with specific goods. Say for example Coca-Cola. If you say Coca-Cola, it is only with the juice company. Okay, the soft drink company. It is not associated with anything else. Say for example Pepsi. Pepsi is for Pepsi Cola. It's not for a property or something, or not for a van or something, nothing like that. So it is for a specific category of goods, not for all. And the moment you get a trademark, if you see the name, there will be an R symbol. That means it is trademark protected. But if you register it, you get increased rights and you can stop others from copying you. But copying is not really necessary to infringe. So I'll show you how that is. It's quite easy to obtain. Only important thing is it should be distinctive. Okay, it's expensive to enforce and litigation is quite expensive. Why? Because trademarks are associated with goodwill. So if somebody tries to copy that goodwill, then you have to go for litigation. So these are some of the best trademark disputes. If you see the name Vaseline, and the name here is Vanillidine, so it's very, very similar. There's very little change in the names like Goodrich and Goldage. If you are little missing the name, like Rustam and Rustam, okay, a slight name, the box, the color combination, everything looks same, but you will be cheating the customer. If the customer is not very knowledgeable or not properly seeing, he'll be hoodwinked. Trademarks associated with services is called service marks, and these are associated with, say for example, insurance, banking, railways, transportation, research labs, etc. The next important category is copyright. Copyright has a very narrow protection. It is basically for the expression of a thought and not the thought itself. Okay, you can use copyrights for two-dimensional and three-dimensional things. And the moment you register the copyright, you can use that sign C on the product, on the book. If you see lots of novels, they have the sign C. That means it is copyright protected. It's not very expensive. There's no much scrutiny, and it's low cost to register. And the length of protection for copyright is very, very high. After the death of the author, 50 years, the term still is present. And the moment you create it, copyright is created. It's very easy to obtain, but the difficult point of this is it is the expression. Say for example, Mona Lisa. Mona Lisa is actually a portrait of a woman. But unless you actually copy the whole picture, that picture itself is copyrighted. But if somebody else wants to just sit down and make a portrait of their own face, that is not copyright infringed. Okay, it's not infringed. It is, if you will copy, if you keep Mona Lisa's picture and copy it exactly, only that is copyright infringing. Okay, so it is expression and not the idea itself. It's how he has painted, what strokes he has used. The same thing with movies. If you're talking about a movie story, like in the movies nowadays, copyright is what is used to protect the movies or the songs. Unless you pick up all the words or the exactly the same storyline, it is not copyright infringing. So if you make drastic change in the storyline, yes, that becomes another movie and that is again copyrightable. But if you are exactly copying, then it is copyright infringing. The next thing is geographical indications. Now, geographical indications are for goods, okay, goods and varieties of products which are originating from a particular territory or a country, and the quality of that product is due to that. The reputation, the quality, the characteristic of that goods is essentially attributed to that particular region, okay, to that climatic condition or to that particular region. Some of the best examples is Kanchipuram silk here, Darjeeling tea, and we have so many GI registered products from Tamil Nadu now of late. Similarly, if you go around the world GI hunting, you will see specific ones like Rockford cheese and Bologna meat, wines, chocolates, Swiss chocolates, okay, dairy products from Switzerland, like that. So many different. Each country's product is defined. Basmati rice from India, it's like that. Rasgulla from Bihar, from West Bengal, Calcutta. Here, the objective of geographical indication is that the customer should not be misled and you should not give wrong marking. Okay, and the region, the place from where it is arising, they should get the economic benefit. Say, for example, Kanchipuram saris. The saris are from Kanchipuram, they have the typical silk, okay, and they have the temple border or the design, the silk, the amount of silk they use in that Kanchipuram sari. So those things are attributed to just Kanchipuram. So that is why they put the silk mark, and the people, the weavers from that particular region are benefited because they'll have that specific amount of silk used, okay, and they will all retain to the requirements which they have agreed upon, and all of them will have the same kind of quality, and it will not be less than that, and you will not be hoodwinking the customers, as well as they will also be benefited. So there are several examples like Darjeeling tea, Basmati rice, Kolhapuri chappal, and so many Nagpur oranges and all that. So that is about GI. The next thing is about plant varieties protection. India has the plant variety protection. We don't give patents for plants or seeds, but we have a different kind of protection that is for plant varieties. Now, this plant variety protection was actually done in 2001, and it protects plants or new plant varieties. But the variety has to be new, it has to be distinct, uniform, and stable, and it must have satisfactory denomination. It means the variety should not lose its qualities, and it should have proper offspring. That is, the line should continue. It should not die after 2-3 crossings. So it is called the DUS requirement, the distinct, uniform, and stable. And plant variety protection. Plant Varieties Act in India gives rights to both the farmers and the breeders. So that is the most important thing here. Okay, and due to which new plant varieties have arisen, and you can register them. Okay, but only with means of plant variety protection. Now we are going into more detail about patents, because patents are one of the most important intellectual property. Uh, is it fine? Are you able to hear me? Hello?
Yes, ma'am.
Are you people able to hear me?
Yes, ma'am. Yes, ma'am.
Yes?
Yes, ma'am.
Hello?
Ma'am, yes, we are able to hear you.
Yes, we
Please
are able to
continue.
hear you, ma'am.
Okay, okay.
Yeah.
Okay, now we will talk about what is a patent. Patents are exclusive privileges which is given by the government, not by any other person, but by the government. So it is a exclusive privilege. Exclusive means only you can use it. And to whom the government is giving? To the patentee. The patentee means the person who is the inventor or in whose thing the patent has been filed. And it is for a limited period of time, that's for 20 years. For what? For commercial gain. See, if you do not exploit it commercially, there is no point of filing patents. So patents' main purpose is you should exploit it commercially. And in return, what do you give back? What is the patentee giving it to the government? He is disclosing the invention. So patent is important because the patentee, that is the inventor, can exploit it, and what the government is allowing him to get back in return, that is the full disclosure of invention. So it is a synergistic effect. So it's benefiting both the patentee and the public. Okay. Now, once you get a patent right, what you can do? You can stop everyone else from making it, using it, selling it, importing it, the product or the process in which your invention is throughout the country. For how much time? For 20 years. But in response, you have to also pay the maintenance fee. Maintenance fee for this 20 years. Now, each and every country has its own law. Some countries allow a lot of things, some countries don't allow. So that is called territoriality. But there are also privileges to apply for one patent application in several countries. That's the PCT. So now we will not touch upon PCT. We will just go for more simple things. And there's another logic of saying first to invent and first to file. For patents, it's always the first person to file. You may be the first person to invent, but we are only concerned about who is the first to file. If you file first, you get the first benefit. Okay. So what are the requirements for a patent application? The first thing is it has to be new. The second is it should be non-obvious. Non-obvious means no one should have thought about it. Third is it must have a utility. That is an application. And there must be proper disclosure. If you don't disclose properly, it is not satisfactory. So this is a crux of what we have discussed till now. What is a patent? The patent is a techno-legal document. It has technical matter and it is a legal document because the government is giving you the rights. Okay, it will be going to court. So it's a techno-legal document and it is given to the inventor or the person to whom he is assigning that. The government is giving him the rights for how much? For 20 years so that he can exploit and make money. But for getting it, it has to be novel, it has to be inventive, and it has to be industrially applicable. So what is novelty? Novelty means it should not be known already. Prior art means in the prior knowledge. Prior art means anything with the public knows, public disclosure, public use or printed material, internet publication. Nowhere this technology should have been known. And it should be industrially reproducible. You should be able to make it in bulk. It should not be like each time what you get will be different from the past. It shouldn't be like that. And it should have an inventive step. Okay. So what is an invention? Invention can be a process, it can be a method or a method of manufacture. It can be a machine, it can be an apparatus or it can be an article. It can be a substance which you manufacture or produce. Or it can be any useful implement. Okay. So this is how innovations have happened. We have machines which were so big to compressed and it has become, this is the 1946 computer. So innovations have helped it to come to this level. Okay, from this level to this level. And now we have much smaller ones thanks to technology. Then there's something called unity of invention. In your one application, you could have a single invention or you can have a group of inventions which are linked. So the linkage can be the product the process you made the product and the use of the product. Or it can be the process and the apparatus you use to make this process. Or it can be the product, the process by which you made the product, and the apparatus which was used to make the product. So they are all connected by means of this product. So why do you have to actually patent? This is to encourage inventors and provide disclosure of invention, and it gives benefit both to the public and to the inventor, because we are getting new better stuff and the inventor is getting the commercial gain. And by working the patented invention in a commercial scale, you will get reasonable and practicable time, you get better advanced technology and at reasonable cost. That is the objective of patents. What is the advantage of getting a patent? You can avoid duplication of research. Otherwise, everybody will be doing on the same level. And you'll get better, latest technology stuff. And you get improved technology in the industry. You get cheaper and better products. And it's actually useful for achieving success in industry or research or R&D institutions. Now we are going to the next most important part of the non-patentable subject matter, that is, in India, if you are filing a patent, what are the things which you can't get patents for? What is not patentable in India? This is basically for biology people, most of these, and then we will be doing a generalized one. So section 3B does not allow commercial exploitation which is contrary to public order or to public morality. Say, for example, cloning human beings, modifying the germline identity of human beings, or using human embryos for industrial or commercial purpose. They are not allowed under section 3B. Similarly, if you are having an invention which can cause prejudice or harm to the health of human, animal or plant or the environment, it is not allowed under section 3B. Examples like adulterating food, causing mass destruction to plant and animal, all these, or making a very infectious organism, infectious flu or something like that. Now these kind of technologies are not allowed under section 3B. Then the section 3C, where mere discoveries of scientific principles or abstract theories or discovering any living thing. Any living thing means, say you found a new plant or you found a new microorganism or you found some small animal which is having a lot of application in medicine. That is called discovery. Similarly, if you find a non-living substance, say for example a soil sample in which there is some kind of mineral, if you say, I have discovered this new mineral, that is a discovery and that is not an invention. This is all coming under discovery. Say for example, a new protein or a gene sequence you have identified from the human body. Now that is not allowed under section 3C. Like natural gas or mineral or gene or a protein, all these are not patentable unless you modify it. Section 3D, finding out the new use of a known substance or a new form of a known substance or a new use of a known process or a product. It's not patentable under section 3D. Say for example, aspirin is known for pain and fever. If you find another use for it, say for example for cardiovascular disease, so these kind of new uses is not allowed. Say for example, you're using iron for a particular application. It is iron chips. Now you say, I'm going to do powdered iron. I'm going to use. No, in the past, what was used is chips of iron. Now I'm going to use iron powder. It's a new form, but it's the same thing. Say for example, you're using ginger for cold. Now you say, I want to use it for cancer. So that is a new use. We know the product, but it's a new use. So that is not patentable because, see, for example, you have a patent for 20 years, you're using it for cancer. Now, if you say I found a new use and that can be used for eye infections, so you will be actually evergreening your patent. So every 20 years you will find a new use and you will keep on extending. Then the purpose of the patent is defeated. So for that, section 3D has been included, and this is one of the biggest thing in uh, patents. Section 3D is world renowned actually now. Lots of countries are interested in Section 3D, but India is the only one who has it now. Coming to Section 3E, a mere admixture without synergy. That is called Section 3E. Now, say for example, you have a hair oil where you add different ingredients which are all going to do, have some kind of effect for a particular disease. Okay, and you add up everything and you will have a better effect, but that is actually an additive effect. You have to show a synergistic effect. Say for example, Brahmi, Shikakai, aloe vera, Bringa, hibiscus amla, they are all known to induce hair growth. So if you say I'm adding all of them and it's a new thing, that is something which is basically additive. But if you will add another ingredient and show that all this individually cannot do it, but together they are able to achieve a third effect, then that is patentable. So that's called synergy data. So whenever you do add mixtures or compositions, you have to provide synergy data. That is a no effect data. The next thing is method of agriculture or horticulture. Let's say for example crossing or preparing improved soil using earthworm, for fertilizing the soil, or using cow dung to fertilize soil, improve the use manure and all. These are all methods of agriculture and horticulture, and they are not patentable. Section 3I doesn't allow processes for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or any treatment of humans or animals. So any kind of treatment or diagnostics in vitro or in vivo is not patentable under Section 3I. Say for example, like removing cancer, blood transfusion, vaccination, surgical procedures, okay? All this is not patentable under Section 3I. Plants or animals in whole or any part, including a cell, seed, variety, species, or essential biological processes are not allowed under Section 3G. So life is not patentable. Only microorganisms, that too genetically modified organisms, are allowed. Beyond that, nothing is allowed, whether it's plant or animal. But plants you can get with plant variety protection. That's for a new variety, but not for a plant or a seed or a cell or an animal. Okay. Section 3K doesn't allow mathematical methods, business methods, algorithms, or computer programs per se. If you have presentation of information, that is also not allowed under Section 3N. Presentation of information, like say for example, these two examples I've given you, you can go for copyright. In copyright, you will get protection, but not in patents. Now, there are another few non-patentable inventions like Section 3A, where inventions which are contrary to well-established natural laws. If you say water doesn't go down, gravity is not active, actually my invention is flying up. So without any support, if you say it is defying gravity, that is against natural laws. So we don't allow patents. But if you show the technology how you can do it, yes. But if you just say that my invention is against natural law, it will defy gravity, then we don't allow them. Mere arrangement or rearrangement or duplication of known devices is not allowed patents. A literary, dramatic, musical, or artistic work, or aesthetic work, or cinematographic work, or a television production is not allowed under Section 3N. We can use it for, you can use all these things for copyright. You can get all these things with copyright. A mere scheme or a rule or a method of performing a mental act or playing a game is not patentable under Section 3M. Topography of integrated circuits, there is a totally different integrated circuit protection board. So you don't get patents for even them. Then there are some non-patentable inventions in under Section 4, which is very important. Inventions which fall under section 21, which is atomic energy related, radioactive elements, are not patentable. So any invention which relates to compounds like uranium, thorium, beryllium, plutonium, radium, graphite are not allowed patents. So anything which is associated with fusion, fission, or atomic energy are not allowed patents. It has to go to the DAE, Department of Atomic Energy, and only when there is clearance from DAE, they can be patentable. Otherwise, all these inventions are put under section 4. So if you invent, what do you do? When you invent, you should not publish your invention before filing the patent application anywhere. And if so, if you do that, you have just 1 year within which you have to file the patent application. So you could first file a provisional application, which means the first temporary one, and you have 1 year by which you can file the complete specification. Then you can check for the technical and commercial viability, whether really you can improve your invention or whether you will get support to commercially exploit it. And if you are saying it's yes for both of them, then you can develop it and file it, and then file the request for examination within 48 months. Then get the patent and then commercialize it. When you commercialize it, you mean to make it on your own or sell it or license it if you don't have the time, or assign it to somebody else to do that. And you have to do the field watch. See if somebody else is utilizing it, using it without your permission, because you will have to sue them. Okay. With this, we finish the first part. Is there any doubts you want to ask before we go to the next?
No doubts, ma'am.
Okay. So let's start the second part. That's filing procedure, filing patent application and the procedure. There are different types of patent applications, so I won't bore you with too much of it. I will tell you in the most simplest manner. You can have the ordinary application. So say for example, you are the inventor. As soon as you, okay, we have ordinary application, we have convention application, we have PCT. PCT helps you to file one application, and you can use that and go to 135 countries. So PCT is very important if you are doing entry in one, and you can go to several if you want to really go into many countries at a time. And you have others like patent of addition and divisional application. The day you file, it's called the priority date. So I think I will not touch upon much about patent of addition and divisional, because now I think it will go over the head. So let's see who can file the application. So I want you to remember one thing. In patent applications, you have ordinary application. Like if you're just filing in India, it's called the ordinary application. Or you can file the PCT, with which you can go to several countries in one go. It's much more better to file a PCT application if you are targeting several countries and not just India. Okay. Who can file the application? You can file it alone, or you can file it jointly. Like 2 or 3 people, 4 people who can file it. It can be filed by the inventor, the true and the first inventor, or it can be filed by the assignee of the true and first inventor. Say for example, you are from you are from DG Vaishnav College, so you are the student. Say for example, Mr. Augustine. Yeah, Mr. Augustine, he is the one who is the true inventor. So he is the inventor who invented a particular thing. Now the assignee will be the college, that is DG Vaishnav College. So they are the assignees because he is using the lab setup of DG Vaishnav. Okay, and he is using the students. The students are also from the same college. He's using the technology, the internet, the chemicals. Okay, the lab setup of DG Vaishnav. So he assignee will be DG Vaishnav. The inventor will be Mr. Augustine and his students. So either it can be alone, he can file alone, or he can be with his students, but he will only be the inventor. The assignee will be the college. But if he talks to the college and say, I have not used anything, then only the students and he can file. So it will be the true and first inventors alone. Okay, or it can be the legal representative. Say for example, the person who's doing it has left the organization, then the legal representative. Or if the person is dead, then his legal representative will file. Okay, now say for example you are the inventors, you can first file a provisional specification. A provisional specification means it's one of the most simplest documents in which you are just briefly describing, just giving the outline. It is the coursework, okay? I mean it is a description of the invention, essential features are there, but it's not the fine-tuned document, it is the course document. So there is no claims and no much details, but it gives you the brief outline. Now after this is called the provisional specification. Now why do you have to file the provisional specification? Because the important rule of patents is the first to file, not the first to invent. So you have the outline of the idea or the plan. You don't know if it will really materialize, so you will first file the provisional specification. Now you have 1 year time. So now you can disclose it to an interested person. You can get financial support. You can use this time to commercialize. See if people are actually going to buy your product, or you are able to actually get the kind of output from your invention. If it's not working, then you can just forget about it. If it is working, then you can actually go forward and modify to commercialize it. Then you will file the complete specification. Now what is there in the complete specification? The complete specification is the complete document of your invention. Now it will have the title, the field, the use, the prior art. Prior art means what is already known. So before you start doing any work, say for example, if you're working on COVID vaccine, for example, you will have a lot of study to be done on the, you will be studying a lot on what is already available in the market, what people have done, okay, and where is the problem. So that is called the prior art, what is already done, and what is the problem with the prior art, and where yours, the big difference, where is it coming, and what is your aim. Okay, so if you say prior art is, for example, the COVID vaccine, you can say there is a lot of prior art, there are so many people doing, so all that will be in the prior art. The drawback of the prior art is it's having allergic reaction, and you don't know if there is immunity, how long immunity is there, or if it is actually effective. So you can compare all that. Then what is your aim? Your aim is that there should be no allergy and it should be a good vaccine, okay, with no allergy reactions, and it should show good immunity also. Then you will talk about the invention of yours and give the detailed description, and you give the data, the drawings and the data that yes, I have done and it has worked, and my vaccine is better than the prior art, whatever is available. Okay, it is not immunogenic, it is not allergic, okay, it is really good. It's also working well with the South African or the UK COVID viruses also. So you can give all the data, and then you will give the most important part, which is the claim. The claim is actually the boundary, which is the most important part of the invention. Now, what is a claim? Your claim is the boundary wall. It is the exact boundary of monopoly of your invention. So it should be very clearly and with a lot of precision you have to write it. So it should relate to just one invention. It should be very clear and concise, and it should be based on what you have disclosed. You cannot disclose a pencil and you cannot claim a writing instrument. So what you have disclosed, only that you can write. So the claims, you can have a principal claim, which means the first claim. Principal claim means the first claim, and it can be an independent claim, and it should define all the essential features, the most important and the new features. And you can have the subordinate claims, the claims which depend on this main claim. They are all the subordinates. Say, for example, the principal of your college and all the subordinates. It's something like that. So this is the head claim, and these are all the subordinate claims or the different dependent claims, and these define the optional features. This may or may not be, but the most important features have to be in the principal claim. Now, a strong patent is something which can withstand the challenge in the court. The invention, if your patent is strong, it must be a good invention, and it should be marketable. It should also be very well written. So in your complete specification, you will have the specification and claims. Your patent application has two parts. One is a specification, which has to be very well written, clear, organized, and all that. And it will have all the prior art. What have you done? What is the advantage of your invention? Your the examples and your data. All that has to be in the specification. The claims must be written very well, and it should be a little broad but meaningful and supported, and it should be difficult for others to work out, and it should be drafted with different perspectives. So the claim is the most important part. Okay. Now, the documents you need for filing application for a patent is the application form. It is there in our website. It can be the provisional or the complete specification. So if you are filing provisional, you have 12 months to file the complete. If you don't file it, your application is dummy. It is dead. The third is the proof of right. If you are the inventor, you have to sign. Say, for example, if it is Mr. Augustine, he has to sign and give a letter that the Geographical College, I'm giving my rights to it. So that is called the proof of right. The inventors all have to sign. Then a statement of undertaking, whether you are filing in other countries. Okay, foreign filing details is called the statement of undertaking. If you are not filing directly, you are asking a lawyer to do it for you. You have to give the power of attorney. You have to declare all the inventors. And if you are filing in other countries, you can give a certified copy. If you are filing in US and you're coming here, or if you're going from here to there, you can give a certified copy. This is all optional. The abstract, the summary of your invention, or one-page summary of invention. And if there is any drawings, and your form 2, this is the whole document, it's already there. And drawings, it's separate pages. If there is sequence listing, that is another part. It's a part of the complete specification, but again it should be in a different page. It should start from a new page. The claims, it also will be starting from a new page. And then the fees is for an individual, it's 1,600. If you're doing online filing, it's 1,700. If you're doing online filing, it's 1,600, and if you're doing physical filing, it's 1,750. So it's 10% extra. If you are a SME, a small medium-sized enterprise, then it's 4,000 and 4,400 if you're doing physical filing. If Mr. Augustine is filing directly, that's called an individual. Then the fees is 1,600 and 1,750. But if DG Vaishnav, that's an organization, is filing, it's 8,000 and 8,800. So if you're doing physical filing, it's more. If you're doing electronic filing, it's 10% less. That's why I have put the bar for electronic filing and physical filing. And these 3 fees I have given you for individual, a small medium enterprise, and for a company. Okay. This fees is for 30 pages of the complete specification and 10 claims and 1 priority document. If you have more than 10 claims, then for each claim, the cost of the claim will be like 320 if you're an individual, 800 if it's a SME, and 1600 if it's a company. Okay, and if there's more than 30 pages of complete specification, for each extra page you will have to pay fees. Okay, that's down. After this, you have to file the request to examine it. That fees is extra. If you don't want to wait, you want to go very fast, you have the option of expedited examination. So that fees is also mentioned here. Publication is done before examination. We publish the document so that everybody who's interested can see it. So publication is after 18 months of filing. So still 18 months after you file, we keep it in secrecy. But if you are interested for an expedited examination, you have to file a request for express publication. This much is fine. Is it clear? Yes. I assume that's a yes. So I'm going forward now. So we know what are the documents we need to file, what the CS must have, what the claims must have. Now you have come to our office and you are filing. So once you enter our office, you have come to our office. Today it will be the filing date. So next we will classify it according to international classification and Indian classification. Once we do it, we assign it to the particular group. So we have chemical group, we have mechanical, we have computer science, we have electronic and electrical group, and then we have the science category of chemistry, biotechnology, microbiology. Okay. So depending on your innovation, it will go to the particular category of people. Then it comes to the examiners. Examiners will do formal and technical objections and examination, and they will put the objections. After doing that, it is properly examined, searched. Actually, we search for novelty, inventive step, and the most important, relevant, closest documents are cited. We make a proper report, and then we send it to you. Now, the inventor can see the report. He can continue whether he wants to. He can decide whether he wants to continue with examination, or he can just keep quiet. Then the application is dead. Or he can give his submissions. So if he feels that it is not in favor of him, he can withdraw his application, or he can continue. He can give us clear indications as to where his innovation is better. He can prove if we ask for some data, he can provide the data. Or based on the objections, he can modify or delete some things, and he can reply. Once the reply comes, again, we examine it. So you have to actually write back and send it back to us. So again, after this, we will re-examine it. If we examine it, we find that yes, we agree with the inventor, the report is written and there is no more objections, so the patent is granted. But if we don't agree that it is grantable, we are still having some objections, so we call the inventor and we discuss the case. So at that point of time, if we still say no, it's not allowable, then we provide an oral hearing. So in the oral hearing, the inventor or applicant can discuss with the controllers, okay, that what the problem is. They can try to convince. If we still say no, it is refused, the application is refused, okay, you can go to appeal to the intellectual IPAB or then to the High Court. But if we agree with the applicant and it's a grant, so inventor can modify the claims or persuade us that he's correct and we are wrong, and the patent application is granted. So once it is accepted, what happens? Once the patent application is in order for grant, there is it is again, once it is granted, it is published in the Gazette of India. Now, there are 3 to 4 months period is there for opposition. So if somebody once it is published, anybody who is interested will be checking the Gazette of India and they can file a opposition. Opposition means they'll actually say that this is wrongly done, or this is something which is known. Okay, patent office has missed it, or it is my invention and he has cheated me and taken. So anybody can oppose. Now, when the opposition comes, again it comes in front of the controller who handle this case. Now, both the parties will argue the case, and based upon that, the patent may be either granted or it can be revoked. So if it is revoked, you can go for an appeal, or it is once the oral hearing happens, either it is revoked or the patent is granted. So once your patent is granted, we will send you a letter saying that a patent number is generated and it is given to you. So you can be very happy, it's done. But then you can't just walk away. So we'll see what should be done. So this is the whole procedure. Okay, how in the normal procedure it is almost taking 27 months. But if you are doing expedited examination, you are having almost within 8 months, the whole procedure is over. But you'll have to pay fee for that. So once you have got the patent, what is the duty of you? Can you just walk away? You can't. You have to give the report of the commercial working of the invention, that you're really working it out. If you're not working out, there is again a clause wherein somebody else can ask permission from the government and work it out. So you have to every 3 months give the commercial working of the patented invention. You have to show the periodical report that you are working it in India, and you have to pay the renewal fees. So from the 3rd year only you will be paying. So again, the difference in cost, individual, small, medium company, and small, medium enterprise, and then the company. So it's almost 4 times. So from the 3rd to 6th year, this is the cost. 7 to 10 year, this is the cost. 11 to 15, and 16 to 20. 28th year, the patent will lapse after the 28th year. So this is the duty of the patentee. Now there are different organizations which provide support and assistance for drafting, okay, for product development and for funding from the government and NGOs. TIFAC, PATSIA, DBT, they are all helping. And there are different organizations which help from drafting to funding. So they also help in searching and drafting. Okay. So patent drafting can be done by agents. Okay. If you can afford them, or government organizations or NGOs. Okay. This is the different country websites. This is our Indian Patent Office website. You can visit the different websites if you want more information on patents. Okay. So once you get the patent, what do? You were supposed to manufacture or sell. If you think you don't have that much time, you can transfer the rights to somebody who's interested to do so, or you can license it, or you can assign it, or you can cross-license it. And in the meantime, you can even improve it with further R&D. Okay. There is another clause I told you. If you are not working it, if you have got a patent and you're not working it out, okay, you're refusing to work the property in this country within a certain period of time, that is 3 years for India at least, a third party can apply for a compulsory license. He can go to the government and say that, see, he has got the patent, but he's not working it in India. Okay, then, and from past 3 years, he's bringing the drug from US. He's not doing it in India. Then the government of India, without the consent of the owner, will give him the compulsory license. But he has to prove that the inventor has not done it in India. It's very costly. The amount required is not meeting because he's importing it, and it's really very expensive. If he can show all that, the government will issue the compulsory license. So the grounds for which he has to prove is, the grounds are 3 years has happened since the grant. The requirement for the public needs it. Say, for example, this cancer drugs. Most of the drugs are actually being produced abroad. They are not produced here. Okay, and so it is imported. So the cost is very high because you have to pay the customs duty. So the cost is not affordable, and the the amount of requirement is much more, but what is imported is less. So reasonable requirement of public is not met, and it is not worked in the territory of India. If you can show all these three things and the 3 years has expired, then you get compulsory license. Okay, now we are going to another part. This is infringement. If somebody without your permission is infringing means using your invention or making your invention without your permission. Without your permission, they are using your invention. Then you must be really getting mad. So what should you do? You should first send a notice that your own patent, that you have a patent and his activity is infringing it. If he does not reply or say that no, I am not doing that, then you can file a suit in the district court and you can claim the cost. Claim the cost of your legal expense and your own patent loss. Okay, that because of his doing, you are losing so much money. Okay, and precautionary measures is the most important. That is, you should watch the industry and patent databases to see if somebody else is making their products using your technology. But however, if you're using a patented invention for teaching or experiment purposes, okay, without the consent from the patentee, without paying royalty, you can use. But it's only for experiment and teaching. The moment there is an intellectual property coming out of this experiment or teaching, then you will have to pay royalty. Till the moment it is for experimentation, it is fine. You don't need to pay or get consent from the patented person, from the patent. So creativity and invention without wealth, creation is not an innovation, is a very good saying from Jerry Ellis. So if you file patent, the most important thing of any intellectual property is to commercially exploit. Without commercial exploitation, creation or invention or patents are not innovation. So there is no purpose in that. So for any information, you can visit our website. All the information, data, everything is available. So with this, I end. You can, if there's any questions, I am here.
Ma'am, thank you, ma'am. Any questions? Students can answer now. Ask questions now. There are no questions. Ma'am, it was a very informative.
Ma'am, I have a question, ma'am.
Okay.
Yes.
Thank you very much for your very elaborate and a very interesting presentation indeed. And we always love the way you present. So, so last year also we enjoyed the way you communicated with us. And I have a doubt, ma'am. Like I actually filed an application for a trademark, and I filed it in the month of August. So it is a trademark for my educational initiative, and it has crossed several stages now, and it is still pending. And what are the major things that one has to cross to get the trademark?
Is it distinctive?
Yes, ma'am.
Is it distinctive, the name?
Yeah, its the name is
Is it
very distinctive, ma'am. It's a distinct name. Yeah.
Sir, I think in our website you have the trademark search option. Have you searched it? So I don't see why it is still pending.
Okay. Because
Yeah.
I actually did it through an agency.
Okay.
So I paid the requisite fee, and they told me that in another couple of months it will be over. But still now it has there was no claim because it has been published in the website, and still there is no claim. So I think they will no. My question is, why it takes such a long time, or what is the time duration normally for getting a trademark?
Actually, I'm from the patent department. So the TMR is just nearby. It's just the next department. Actually, see,
Okay.
we are totally different departments.
Okay.
The way they work, I think it is because there is a lot of pendency. So I think they have done a mass recruitment. I think the number of people there are less, but TMR, I think it's much faster. I don't know the reason why it's delayed.
Okay. Okay. Okay.
But I think due to COVID, a lot of people from the TMR were infected, so
Okay.
they have had a little lag because almost 3-4 people in TMR group have the examiners basically. I think at least 2 of them got infection, so they had closed down the office for some time.
Okay.
You know? So I don't think there is an issue with that. Now that you said there is no, what about objections? The objection, I think one time you have already received the communication, right?
Okay. Students, you can post your questions, you can post your doubts. Ma'am is she can give you all the answers. Ma'am, there is a question. After filing a patent, can the true patentee include or exclude a person under the patent?
Yes. See, but all the inventors there have rights. So they have to, if somebody has been excluded, the reasoning must be there, and that person also should agree for that. You can't just remove it because there are lots of cases where several inventors come and say that they have not been allowed. Okay, their name has been deleted, so they can file opposition. A lot of people do that. So if a person's name has to be included, all the other inventors have to sign and say yes. And if a person's name has to be deleted also, the person whose name is deleted has to say yes. You can't just delete and you cannot just include also. Everybody has to agree. So this is a patent application is a techno legal document. So it is a legal document.
Okay.
So everything has to be done properly according to law. So if you want to remove, even that must be with permission. He must say that yes, I have no objection. Otherwise, you can't delete. Without proof, we won't remove anybody's name. Without proof, we won't include anybody's name. What was filed, that so it remains.
Ma'am, I have one more question. Now, can I patent a published work of mine? Say, I have already published it in a journal, and can I patent it?
Within 1 year timeline, then yes, you can.
Yes, ma'am.
Within 1 year,
Oh,
if you
within
have
1 year of
published,
publication. Okay.
because when we search, we will search with the keywords from your written work, whatever you're
Okay.
filing it. So when we search, your own document will come as the prior art for us.
Okay.
So we will see whether it is within 1 year. Otherwise, we will be citing your own document saying that is prior art.
Okay. Okay.
So
Okay.
if it is within 1 year and it is your name, then it will not be because it is within that 1 year time.
Okay.
If it is beyond, your own work will be the prior art, so it will be lapsed. So
Okay.
it will not be any more novel.
Okay. So within 1 year, I should go for the patenting, even if it is my own published work.
Yes,
Okay.
it need not be just published work. If you have actually given a seminar somewhere, or
Okay.
you go to conference, it will be coming in the abstract portion. Even
Okay.
those kind of things, small things. Because when we search, we even get these international abstracts coming, the paragraphs, small posters. It can be any of them.
If any of a student come out with a product, an innovative product, but the process is a well-known process, but the product is quite innovative, can they get a product patent?
Definitely.
Okay.
It is the choice of the inventor whether he wants to, among the plurality, what I was telling you. If the person wants, he can just go for the product. He can only go for the process, or he can go only for the use. It's his choice that he wants all three or two. So if it's something known, then he doesn't want, then he can leave, he can just go with the product. But if both are new, he can have both in one application.
Okay. Any questions from the students? You can interact with ma'am. She is available. What are the scope for patenting from for the students of arts, especially commerce, economics, um, sociology? What is the
So
scope?
patents can be in any field of technology, and intellectual property rights, as I told you, is a creation of intellect.
Okay.
It depends who wants to explore it in what way. Say, for example, an accounting person is making an accounting software, okay, or a different method of calculation. So he can apply for that.
Okay.
Or he made an algorithm. He can use it. So it is how you use your intellect. And patents can be filed in any, any branch of science. Maybe somebody did a cryptogram. Maybe somebody did a cryptogram with DNA.
Okay.
It could be anything in any field of technology. So there's nothing like only science people can do. IP is actually in any field of technology, and it is the beauty of our brain, the exploitation of our brain, the creation of our brain. So
Now, as a person who has traveled abroad and having studied in abroad, uh, what what do you think that why there is a lot of vacuum in this area as far as our education system is concerned? Do you think that our curriculum is not matching with the market, or why students are not thinking about innovation, or what do you think that what do you think that can improve the situation in the coming years? Or in other words, to put
I
it
think we are
plainly,
more.
how can we make our students more innovative?
I think our whole educational system, or I think the pressure of our society is too much for us. We are
Okay.
not studying because we want to study. Okay, we are not studying anything, or there is, I think, among in your whole class, for example, say for example you have 50 students. I think maybe one student really wants to do commerce because he loves the subject. We are all doing it because we have to do something, we have to get a job. That is what is pushing us, driving us. But that is not the kind of pressure which you see abroad. In
Okay.
abroad, they are studying because they have a passion for that. They love
Exactly.
it. So that is actually pushing the boundaries. So it's not like every Tom, Dick, and Harry is going into the college. Nobody is doing that there. So only one Tom and only one Dick is going, one to engineering college and one to medicine. So they are going because they really cherish it. They love it. And that's why the amount of love they put into it is giving fruit. And I think they have better access. Like, I think the kind of projects they do in our school, in the school level there, even our PhD students are not having that much facility here. Okay, a high school student there is doing PCR analysis and identifying genes. Even
Okay.
PhD scholars here don't have the facility. So you cannot equate this and that. Our situation is different, their situation is different. So we can't actually say that our students are low. No, our students are really good. In our facility, we are doing so much, it's really great. And they can't survive here, but we can survive there. So it's totally different. So I don't think there's anything wrong with our system. It's, I think, our population, we
Okay.
can't really afford that kind of luxury. They have the luxury, yes. So I think we need little push, and yes, if we have brighter revenues, we will do 100 times better than what they're doing. Just like how the whole world is dying and India is able to survive COVID. The same thing, same logic. If we are given that, I think, environment, each one would be really, now, why only one Indian is going to space?
Mm.
We lack resources, that's all. We can do much better than them if we had that kind of a system.
Yeah. So it's the matter of facility in the higher educational institutions and the curriculum. So once we try to input all these things into our curriculum, I think the facilities will also follow up, and slowly in future years we will be able to make a lot of inventions and filing patents. Sujata ma'am.
Yes, sir.
Yes, ma'am. If there are no
Thank
more
you.
questions, I think we can wind up.
I don't think anybody is having any question because the presentation was so nice. It was very informative. So I don't think there is no need for any clarification, I think. Thank you, ma'am. Thank you for the
Thank you
informative
very much.
presentation, and thank you for enlightening our students. I would like to thank our principal, Dr. Santosh Babu, sir, our IQAC coordinator, Dr. Prema ma'am, IQAC co-coordinator Augustin sir, for giving me the library an opportunity for hosting this webinar. Thank you all participants. And I have put the chat in the chat. I have put the feedback link. Please fill up the form and then send it to me. Thank you, ma'am. Thank you for the good
Thank you very
presentation
much.
and accepting my invitation without any hesitation. Thank you, ma'am.
Good day. Bye-bye.
Bye.
Thank you so much, Bhanumati ma'am. And we will be troubling you often. So please help us in making these events a grand success. Thank you once again from our side, and have a great day, ma'am. Thank you.
You too. Thank you.
Thank you.